Welcome back to the Environmental Law Monitor. I'm your host, Daniel Pope. This podcast is brought to you by Bracewell LLP's Environment, Lands, and Resources Practice Group. And we have conversations on this podcast about environmental and natural resources law and policy. If you're listening through our website, we're glad to have you. But probably the best way to stay up to date on new episodes is to go ahead and subscribe to our podcast through the streaming service of your choice. Leave us a positive review if you're so inclined. And as always, my email inbox is open for suggestions, questions, comments, recipe requests, whatever you would like to know and talk about. Today, we are going to be discussing a current rulemaking from the Council on Environmental Quality. That agency oversees the implementation of the National Environmental Policy Act, or NEPA. And we have the privilege today of being joined by some of our friends from the US Chamber of Commerce. First, we've got Chad Whiteman, the Chamber's Vice President for Environment and Regulatory Affairs. And we also have Andy Varcoe, the Deputy Chief Counsel at the United States Chamber of Commerce Litigation Center. And Ann Navaro is joining us as well. She's a partner in our DC office. Chad, Andy, thank you for coming on the podcast. And why don't you go ahead and share a little bit about what you do at the Chamber?
Great. Well, thank you. And it's great to be here with you all. As you mentioned, Daniel, I'm Chad Whiteman. I work on a variety of different energy environmental policy here at the US Chamber of Commerce. In particular, our interest in NEPA is that I lead a coalition of organizations that have really broad and diverse interests across many different sectors, energy, agriculture, environment, et cetera, who are all working together to promote efficient permitting in the federal government. So great topic for our coalition and something we have a lot of interest in.
And I'm Andy Varcoe. I'm a lawyer for the US Chamber Litigation Center, where we file lots of amicus briefs in cases affecting the business community and also participate from time to time on behalf of the Chamber as a party to litigation that has business impacts. I also support Chad's energy and environment policy and advocacy team at the Chamber on legal and regulatory issues. Chad and I are not speaking on behalf of the Chamber officially or anyone else here. We're just offering our personal views. My own legal background's in litigation, but over the years I've become something of an environmental lawyer. And my experience with NEPA is primarily based on two government jobs I've held in my career. And first was my work as a career lawyer in the Agriculture Department, USDA, in the Bush and Obama administrations several years back. And I was in a small in-house team that focused on appellate matters, including recommendations to the Justice Department in cases that we lost on whether to appeal. Many of those cases were NEPA cases brought against the Forest Service and other USDA agencies. And USDA, which is a wonderful agency, is also very good at losing NEPA cases, or at least it used to be. And you do learn a lot about statutes by losing cases based on those statutes. The second job was a stint in the White House counsel's office in the last third or so of the prior administration, where I handle a law and policy portfolio focused on energy and environment, infrastructure, resources issues. And I was involved with the development of lots of regulations in that capacity, including the 2020 CEQ NEPA rule that the current administration is considering revising.
Well, before we jump into discussing the current rulemaking, and I think that's a good segue, I do want to take just a minute to sort of set the table for our conversation for those listeners who might not be as obsessed with NEPA as we are, and describe what the statute requires at a high level. NEPA mandates that the federal government, sort of simply put, reviews the environmental effects of its actions, and that those effects are disclosed to the public. Depending on the nature of the federal action, those reviews can be pretty straightforward, but sometimes they can also get to be quite complex, with some environmental impact statements sort of making War and Peace look like Goodnight Moon. You can tell by now that I have a 1-year-old. But in the 4+ decades that NEPA has been around, it's become much more than a simple review process. It's become a pretty complicated process with a lot of potential pitfalls for federal agency. And Andy, you kind of alluded to that. So here's my first question. Given that NEPA applies really just to federal agencies, why do private companies and non-governmental entities care so much about NEPA? Let's start with you, Chad.
Sure. That's a great question. And businesses, it's really surprising how many things NEPA actually touches. And for businesses across all these different sectors, NEPA folks get involved with NEPA. And so as one of the sort of pre-construction permitting activities, if you have to get a federal authorization from an agency to proceed through NEPA, then making sure that NEPA is an efficient and clear process is a real priority for you. And recently, and for a number of years, NEPA hasn't been that. It's been really costly and burdensome for folks. And so the business community has a strong desire to work with agencies to ensure that they're considering the environmental impacts when they're significant, but also making sure that the federal agency's process is efficient and transparent and as least burdensome as possible.
And I would just add that NEPA doesn't apply to private actions, but applies to federal agency actions. And those include not only authorizations, but also, though the scope of this is somewhat debated, federal funding of a highway project, for example. And a lot of people tend to think about roads and resource extraction, like cutting down trees in a national forest, but it's technology neutral, so it applies just as much to projects that we might think are environmentally beneficial in the long run as it does to projects that aren't seen in the same way. It has impacts for all kinds of energy infrastructure associated with reducing climate change impacts. And although there's a lot of fuzziness in how this works in practice, it applies to a lot of regulations that are thought to have environmental impacts. And so it's just one example I was very involved in at USDA. The current regulatory scheme governing agricultural biotechnology was subject to a lot of NEPA litigation in the Bush and Obama administrations until there was a Ninth Circuit decision that clarified the scope of NEPA analysis that was required. And so you might not naturally think about NEPA in that context, but it was the real focus of that litigation.
So, Daniel, maybe I'll also back up maybe for another kind of table setting point that I think will put what Andy and Chad have said in some context. And this might be particularly interesting for folks listening who aren't steeped in kind of the background of NEPA. But, thinking about when the statute was passed, its goals were very clear, and it obviously retains the same goals, which are to inform the government decision maker and to inform the public before the federal government makes decisions and takes actions that may have environmental consequences. And, it was enacted at a time, in the mid-'60s, late 60s, when there were some pretty significant government projects on the planning board that became very controversial and were of a lot of concern to the public. A lot of the big environmental statutes were being considered and passed. And so it was a time when the government and the public was really focused on the government needing to have a meaningful understanding of the consequences of its decision making. So, it's good to remind folks also that NEPA is a process statute. It's supposed to help the government kind of get to a decision by thinking about things along the way, and it's not supposed to drive or it doesn't impose any substantive standards like a regulation under the Clean Water Act would. But Congress's expectation was that it would, to some extent, drive decision-making by making agencies and the public really think about what they're doing. So it's in that respect, it creates an important foundation for most government decision-making or a lot of government decision-making. And so the process itself and whether it's become overly complicated, difficult, whether the government perhaps can overreach in certain respects under the guise of NEPA, all that is critically important because it really shapes the government decision-making process.
Yeah, and I want to make one point that I think we've all sort of discussed around because it's obvious to us, but for somebody who doesn't eat, sleep, breathe NEPA reviews undergird those federal decisions, right? So you want them to be timely because when you're asking the government for an authorization, usually there's a business timetable in mind. So if it's unnecessarily lengthy or drawn out, that obviously affects companies. But on the back end, there's also a big risk if those NEPA reviews have a foot fault, right? Or fail to review an important part of the question. Those NEPA reviews, whether it's an environmental assessment or a more extended environmental impact statement, those can be challenged legally under the Administrative Procedure Act. And I think about it sort of like knocking a leg off of a table, right? If you receive an authorization as a company to move forward from the federal government, and the NEPA review that undergirded and propped up that federal decision is challenged successfully, well, then that leads to a lot of uncertainty about what you're able to do immediately. So I think those kinds of things just highlight how significant this area is and how it touches, as you all have pointed out, so many different aspects of economic development, economic activity all over the country that might not immediately strike us as being like, oh, well, yeah, that's a huge environmental concern.
Good points. And I think that's why multiple presidents over the years have issued executive orders to ensure that the permitting process is efficient. And I oftentimes go back to the Obama executive order, and the references there talk about making sure that the process is efficient to ensure the movement of the energy, goods, services, manufactured goods, et cetera, that make our economy go. And so there's a real tie there to efficient permitting of these major infrastructure projects because they are often the backbone of the economy, whether it be roadways or railways or airways. And I think, the business community has a vested interest in ensuring that their projects consider significant environmental impacts. They do from a resilience standpoint, they do obviously from the litigation standpoint. But one of the challenges is the average amount of time it takes to put together the environmental documents, sort of undergrid this analysis has gone up over the years. It's about 4.5 years now. But for some particular projects, like bigger transportation projects, the average is like 7 years. For transmission lines, the average is 7 years, like in that range. So when you're talking about 4, 5, 7 years just to get the permitting done, not even talking about building the project and the other planning that goes into it, it really makes it difficult to get some of these things done, which are necessary for not only economic growth, but also helping out some of the communities, in particular now, who are really in need of, say, broadband access or cleaner water or those sort of things.
And that underscores two other foundational points. One is that NEPA is not an umbrella permitting statute, but over the years, the NEPA process that agencies have engaged in under the statute and under the implementing regulations issued by the Council on Environmental Quality has become the focus of, and sometimes the basis of, organizing all the permitting related reviews that somehow relate to environmental or even other considerations like historic preservation, for example, in order to bring some order to what otherwise could be a set of disorganized, uncoordinated reviews that need to be done all in coordination with one another if they're all to be done efficiently and effectively. And some of the recent attempts at reform, really, I think, in large part, particularly since the Obama administration, both at the CEQ level through guidance and through regulatory changes, but also through congressional action where Congress has carved out some exemptions to NEPA in some areas like transportation or directed more coordination of permitting decisions. All that is intended to try to speed things up in a way that complies with all the legal requirements that arise not just under NEPA, but under other statutes that intersect with it in odd ways. The other point to just underscore, the other fundamental point, is that NEPA is a short, rather vague statute. It certainly requires that there be an environmental impact statement in certain circumstances, but there are many generalities, and the generalities are translated into particular requirements by CEQ regulations. And those regulations, even the 2020 regulations, are largely based on regulations that President Carter required CEQ to promulgate that were issued in 1978 that are quite statute-like in some respects. If you're a lawyer who interprets statutes and you look at NEPA and then you look at the regs, you kind of think, gosh, the regs look a lot like statutes in other areas, and courts enforce them, and so agencies ignore them at their peril.
I think if you read the statutory text of NEPA, it's almost like reading the Constitution. And Ann, I know that one of your favorite.
That's how I feel about it.
Yeah, absolutely. She pledges allegiance to the National Environmental Policy Act when she goes to work. No, but there's, sometimes called the Magna Carta of environmental law. And, yeah, it's kind of like that. And so, and to your point that what I think of as sort of like NEPA classic, the 1978 regulations are very familiar. And you also mentioned that prior administrations have often tried to accelerate or standardize or make more efficient the NEPA review process, whether that's a standalone review or in conjunction with other kinds of needed reviews. And so we started, I mentioned that we were going to get to this. And so I think we'll start kind of shifting that way. But obviously CEQ has a proposed rule for NEPA revisions, and it is revising some of the prior administration's revisions to those classic NEPA regulations. My experience in my limited time as an attorney is that to do NEPA, you have to read regulations, and then you have to read a pretty significant amount of case law to make sure you're thinking about those regulations in the right way. It's almost sort of like, Gandalf going into the libraries and searching through all the lore to make sure that, he caught the one reference to the one ring or wherever. Anyways, that's a sidebar. But you have to read those regulations in light of numerous decisions. The previous administration, I think, tried to incorporate a lot of the principles or to distill lots of those principles into a sort of a regulatory facelift of those regulations, or at least that's how I sort of shorthandedly think of that, to provide for more efficiency, to standardize the review process across a number of agencies. And so what can you tell us about what happened in 2020, and then maybe share with us what CEQ currently has proposed and pending?
Yeah, I think from a broad stroke perspective, as you mentioned, the 1978 regs were really the primary, the only time there was a really comprehensive set of regs put out. There were some updates that were done in that interim period, but not comprehensively. And so, as you mentioned, NEPA is one of the most litigated statutes out there. And that means that there's been a lot of case law, a lot of course, and that has directed how a lot of what the agencies do to respond and comply with NEPA. So what transpired over the last 40 years, much of that was incorporated into the 2020 updates. And some of those things were aimed at setting boundaries, clarifying where things were ambiguous, and just trying to ensure that the process that the agencies follow is consistent and transparent. So the 2020 regs were a comprehensive update. They walked through so many different parts of the 1978 regs and really tried to make them more efficient and more predictable. And we've supported many of the provisions in those regs just for those reasons.
So some of the 2020 rule is pretty boring and perhaps non-controversial. Other parts of it are more controversial. Three of the things that the 2020 overhaul did, and it was an overhaul, it took about 3 years to do it. So I was around for part of that, but not around for much of it. Updating old regs in light of things that had happened in the last 42 years, then relatedly codify guidance or aspects of guidance that CEQ had issued over the prior 42 years, though the rule left to CEQ a lot of work to do about how do you reconcile this old guidance with the new rule, and how do you clean it up to ensure consistency and so on. And also codifying Supreme Court case law, which had set some boundaries on what NEPA requires and doesn't require. And then generally, I would say just sort of tighten up, put limits on how much analysis needs to be done and when. So there were presumptive page limits and presumptive time limits on NEPA analysis. There were some boundaries set on how much work do you need to do? When can you say that you're finished and feel that you're safe? And I would say a lot of that is a focus of controversy and certainly careful review by the new administration.
And that rule, the rule that was promulgated in 2020, even though it remains in effect, I think it's fair to say it has not really been implemented by the agencies because the incoming administration very promptly indicated an intention to kind of stick with the old way of doing things unless there was a clear conflict between the old way of doing things and the 2020 rule, in which case additional process had to occur. But so I think it's really, it's never been clear as to whether the 2020 rule would have been as bad as opponents thought it was going to be, or as good as supporters thought it was going to be. So we've kind of been in this, sort of NEPA twilight zone. And as Daniel, as you indicated, CEQ has now indicated that it's going to undertake 2 rulemakings. The first one hitting a few things that I guess were high on the list to change. And then the second one coming later and presumably covering more topics.
I'll add one more thing to that as well. And, CEQ issues their regulations, and in a certain way, I think of them as the model regulations that then agencies have their own individual NEPA procedures to then update. And there are over 80 different agencies with their own individual NEPA procedures. And some of them are much more complicated than others. As you can imagine, the big land management agencies have much more detailed NEPA implementing procedures. But as Andy mentioned, if it takes 3 years, it took 3 years to get those updates done in 2020. It was going to take another year to get those agencies to update, just to propose their updates, and probably another year after that. So it takes a long time just to get these regulations updated. It's moving 4 or 5 year process, and a lot of steps in between.
So, Chad, one of the interesting things about how many different agencies have their own versions of NEPA is that with the prior administration, their revisions to the NEPA regulations tightened up how far non-CEQ agencies could go in departing from or adding to what I think of as the sort of like CEQ baseline rules or the model NEPA review rules. And the concern there was that if you have 3 or 4 agencies involved in making a decision or a set of decisions for a project, and you have each of those 4 agencies is applying some slightly different version of NEPA, that adds to the duration of the NEPA process that you identified earlier. It adds to the length of those documents. And of course, there are potential pitfalls when you're working with that many moving parts. So what are your thoughts on this administration's effort, the current administration's proposed rule to allow agencies to have a little bit more latitude in making their own version of NEPA?
Yeah, it's a good question. And as you mentioned, Daniel, one of the 3 sort of primary things that were proposed in this administration's phase 1 rule. In the 2020 rule, just to go back to that, as you mentioned, they say pretty clearly in the text, in the regulatory text, that those inconsistencies that other agencies may have, that they should make them consistent with the CEQ reg. So it really did guide agencies to stick to CEQ's sort of model. And as you mentioned, I think the challenge is if you have if you have different agencies doing different things, you may have different litigation outcomes that may make the different requirements for folks. And I think probably the most difficult part is in many of these complicated projects, the bigger projects, you have more than one agency involved. It's oftentimes not just one agency. You have multiple for transmission lines or public housing or other things. You're going to have multiple agencies involved. And so if agencies have differing requirements, then who's to say which requirement presides? And so that leads to, it could lead to some real complications just in the decision-making process, because each agency has their own hierarchy and decisions. If they have their own implementing regs that are different, how do they go about evaluating the alternatives for a particular project and prioritizing the decisions? And then I think there will be some real questions as to when they choose a particular alternative, what's going to happen in court when you have these different requirements. So I think there's some real challenges to implementing that, and just not sure how it can be implemented in a way that would make things more predictable and give folks the ability to build the things that we need to build for the infrastructure of our future.
So I kind of wanted to ask Andy a little bit about purpose and need, which is a little in the weeds and a little wonky, but it's very important in an agency's NEPA process to define a project's purpose and need, or proposed action's purpose and need, because that guides what sort of alternatives and the agency has to look at. And the previous definition was a bit vague, but it's been pretty clear in the case law that an agency is to focus on, kind of what the jurisdiction of the agency is, as well as to, give some deference to what the applicant's project purpose is, kind of obviously. If they come to you wanting a permit for a pencil factory, you can't consider whether maybe they should be inventing computers instead of making people pencils. So the 2020 rulemaking attempted to codify those concepts, and that's one of the things that this new rulemaking would revise. And it's interesting to me that CEQ in its new rulemaking has said, no, we want the agencies to have discretion to base project purpose and need on things like our desired conditions on the landscape or environmental outcomes, in addition to the applicant's goals. And I wondered, Andy, what you thought about that.
Well, first, taking a step back, when we're talking about phase one, we should say that CEQ, consistent with President Biden's direction to agencies to reconsider regulations promulgated by the prior administration, has said we are planning to consider revising the 2020 regs in two phases, two steps. Phase one is what we're discussing now, which is 3 proposed changes, limited changes to the 2020 regs that would arguably mostly just go back to the 1978 regs in these 3 respects, but not make any big changes. Phase 2 could be much more comprehensive and more complicated. The phase 1 rule, which was published in proposed form by CEQ last year, and which the Chamber commented on late last year, is now, just a few days ago, landed in the Office of Management and Budget, OMB, to begin an interagency review process where it will, I'm sure all the agencies will have thoughts about what CEQ proposes to do in the final rule, and then will be some negotiation, and then presumably at some point in the next several months out will pop a final rule. And somewhere in there then phase 2 will begin. Purpose and need. I do wonder whether to some extent the current CEQ's concern about the text of the 2020 rule is perhaps based on a misinterpretation of the 2020 rule in this respect. The proposed phase 1 rule expresses the concern that the 2020 rule makes the applicant's goals the sole factor or the primary factor. I don't read the 2020 rule as requiring that or mandating that, and it has enough flexibility built in. But about your question about broader goals being part of the purpose and need, I do wonder whether that creates some problem in terms of creating some uncertainty about, well, what is the scope of the review that's required by the agency? Is it limited to what's within the agency's statutory authority or not? It's been pretty well understood, in part because of relevant case law, that an agency, when it does a NEPA analysis, has to review things that are within the agency's discretion and within the agency's statutory mandate, and doesn't need to think about and write about, let's say, things that could only be done if Congress changed the law, for example. So I do think this is an area of concern.
And I actually think a lot of agencies obviously want to do the right thing and consider relevant issues and make sure they're making well-informed decisions. And I think that's absolutely true. But I also think a lot of agencies are concerned and wouldn't want to have to start to look at things that they feel like is outside their area of expertise. And so I just kind of wonder how farther down that road this rule might push them.
Right. And there are also kind of knotty questions about so-called programmatic environmental impact statements, or the level environmental review. So from time to time, agencies will do, either because they think they have to or because they just want to or they're unsure, environmental documents that analyze the environmental impacts of broad programs, which often take very, very broad policy questions into account. But under the 1978 regs, as they've been interpreted by the courts, as well as the 2020 regs, agencies don't have to repeat themselves all the time when they're making specific decisions based on their prior programmatic decisions. So you don't need to repeat the same 200 pages about the same set of big issues over and over again. You can, what's called tier, you can rely on the prior analysis. And that is in large part because of considerations of practicality, which are very, very important for agencies at just doing their jobs from day to day when they have limited staff who have the training and the time and the resources to prepare environmental documents.
And, it's interesting. Just today or yesterday, CEQ released interim guidance on carbon capture, utilization, and sequestration, which are projects of interest to this administration. And that guidance emphasizes the need to use programmatic EISs and find other efficiencies in NEPA reviews. So obviously these complex questions about what the agencies have to look at and how they have to do it are critical to advancing every administration's agenda, pretty much.
Well, and in this administration, too, with the recent passage of the Infrastructure Investment and Jobs Act, putting $1.2 trillion on the street, we're talking about tens of thousands of bridges that are going to need to be rebuilt. And we're going to want to get those done quickly. I think with the state of how those bridges, how much they're dilapidated out there and some of the failures that we've seen, there's a real urgency to get that money out on the streets and get those bridges replaced. That's just one part of that package. I think there are a number of other things that are huge priorities for this administration. Getting 30 gigawatts of offshore wind built by 2030 and to help with the energy transition. And, we're seeing some of, there have been recent lawsuits filed in one of the offshore wind leases, the Vineyard Wind case. And NEPA, of course, is brought up in there that the agency didn't appropriately consider enough alternatives in their analysis. So as far as infrastructure goes, that's just one part of NEPA, but it's going to be a big part of it for this administration and those after it, because not all these things are going to get built in this administration, but it's going to take even more time for all the things that are on that list to get done, which we're really excited about. The Chamber was a big supporter of the IIJA bill. We've been behind it, and we were super supportive of the NEPA permitting provisions in that would help deliver these benefits of these infrastructure projects in a quicker timeline.
So, Andy, another big revision during the 2020 rulemaking had to do with effects. The sort of classic NEPA regulations talked about direct effects and indirect effects and cumulative impacts. And the 2020 rule focused that inquiry just on effects that could be reasonably attributed to a project, right? And that the agency had some jurisdiction over. So what was the change in the 2020 rule? Why does this administration want to change it? And what are some of the concerns about going back to that sort of language of specific kinds of effects?
Right. Well, I think the specific language in the 2020 rule has to do with effects that are reasonably foreseeable and have a reasonably close causal relationship to the proposed action or alternatives. And that was based in significant part on Supreme Court precedent over the past 30 years. Another important change that the 2020 rule made, as you suggested, had to do with essentially telling agencies you don't need to think about the distinction between direct effects, indirect effects, and cumulative effects. Sometimes agencies have, as it were, gotten themselves tied up in knots trying to figure out how to categorize the effects. And the approach the 2020 rule took was you don't really need to worry about what category the effects fall into. You just analyze those that are reasonably foreseeable, whatever box you might think they fall into. So this is definitely in the category of simplifying and tightening up by providing a principle whereby to determine what needs to be analyzed. You don't need to boil the ocean and what doesn't. Now, if you're an environmental group, you're concerned that, well, maybe this tightens it up a little too much. And there are important environmental impacts that are downstream of the action being taken or somehow related that aren't being captured in the environmental analysis anymore. So that's why this is really an important issue to a lot of different stakeholders on both sides of the debate. And climate change is related. Some critics were concerned that the 2020 rule precluded agencies from considering climate change in their NEPA reviews. Now, the 2020 rule says no, that's still allowed. But then there's a debate about, well, is enough of it allowed? And then the 2020 rule also has a provision that says that cumulative impact defined in the 1978 reg is repealed. And I would, as suggested in the proposed phase 1 rule, I'd certainly anticipate this administration would very strongly consider just eliminating that. Why do you need to repeal that? If I'm the current administration, that's what I would think. So there are big stakes here. But I think as a practical matter, one of the more powerful arguments for the 2020 change was there was just so much uncertainty about what needed to be done that risk-averse agencies were doing more and more and more because they didn't know where the line was. And if you do too much, you might survive judicial review. But if you do what you think is enough, some court might later decide you didn't do enough. So there's this sort of ongoing litigation risk created bloat in your NEPA documents and less than the time it takes for you to do NEPA analyses.
And I would just echo what Andy said, and I think the 2020 regs put some definition around space and time of the consideration of these effects, and that's that's important to provide clarity to agencies when the average EIS is 1,200 pages, including appendices. It's because the agencies are concerned about litigation and trying to cover every environmental effect out there. And I think what those changes tried to do was to tighten that up a little bit to really focus on the significant impacts, the ones that are significant based on, reasonably close causal relationship, close in time and space. And
just to take a really big step back, in 1981, CEQ issued a famous guidance document, famous to NEPA practitioners, called the 40 Questions. And it says, well, we've advised agencies under these new 1978 regs, even large complex energy projects would require only about 12 months for the whole process of doing an EIS. And also for environmental assessments, we haven't really talked about the difference between environmental assessments and EISs and categorical exclusions, which is all very familiar to NEPA practitioners. Basically, for all those agency actions that do not or may not require an EIS, there's still some other level of environmental review that under the regs needs to be done. Well, environmental assessment, which in some ways you could see as a kind of like a lower level version of an EIS, the CEQ of 1981 thought, well, this would take maybe 10 or 15 pages. Now, anybody who does NEPA now knows 10 or 15 pages for an EA, that's like, whoa, that's amazing, because often they're 100 or even 200 pages.
That's right. You've got to make a new pot of coffee for that one.
Looking back on that old guidance, as well as reading the preamble to the original regulations, it really drives home that the intent was efficient reviews that focused on the most salient information, proper public engagement. And so, a lot of the concepts that every administration since I've been working in this business since 1992 has wanted to advance are there. They're kind of the original foundational concepts. I think it's just that a lot along the way, litigation and other requirements and concerns have driven things to a point where multiple presidents over 25 plus years have been trying to expedite and streamline.
That's right. There are a lot of things, a lot of language in the original 1978 regs that talk about being clear and concise and to the point. And it's a real challenge to get there. And that's something we hope that agencies continue, and this administration continues to work towards.
I think that's a great place to wrap up our conversation, Chad. It's really interesting to see both of these things happening at the same time. Further revisions to the NEPA regulations and the sort of very real question of whether those will improve NEPA efficiencies to make the NEPA review process more predictable, more understandable. And at the same time, this massive investment in the nation's infrastructure, so much of which is going to trigger that NEPA review process. And so I think we should get back together in a year or so to discuss whatever happened with this phase 1 rule. As Ann mentioned, there is a phase 2 rule that we might see from this administration that may add a few new features to the NEPA regulations. Obviously, we will be watching those. So thank you, Chad. Thank you, Andy, for coming on the monitor. Thank you, Ann, as always. Thanks, Emily, Dorn, and Julia, who make us sound a lot better than we do normally. So thank you all for that. And thank you most of all, listeners, for spending some time with us today. You've obviously heard how 4 NEPA nerds can get really into the details and talk about all of these different features. But of course, we will be paying attention to these new developments and we'll be discussing them here. Thank you.